For 2.5 hours this morning, the justices heard oral arguments in 4 same-sex marriage cases consolidated under the title of Obergefell versus Hodges. Here with highlights and analysis of today's sessions are constitutional law professor Glenn Smith with California Western School of Law and legal analyst Dan Eaton. And Dan, what are the key questions the justices are considering in this case?
Peggy, there are 2 questions before the court. One, does the 14th Amendment of the United States Constitution require states to issue marriage licenses to couples of the same sex? 2, are states required to recognize lawful same-sex marriages that are performed and licensed in other states, even if those states themselves do not recognize those marriages?
So that's a different consideration that I want to wrap back around to in a bit. But Glenn, Mary Bonato, a prominent gay rights attorney who's in support, obviously, of same-sex marriage, opened the hearing today.
Right.
What were some of the questions asked of her?
They were typically the questions I expected. Why should the court stop the democratic state-by-state decision and discussion of this issue? Because marriage has traditionally been thought to be between opposite-sex couples for so long. What's the reason for changing it? Do the precedents that apply to marriage liberty and to equal protection extend to this context? It was not surprising. What I expected, pretty much.
And what about the key arguments against same-sex marriage? Were they what you expected as well?
Yes. The arguments that were made by the opponent were very traditional. They basically tried to say that we have a very low standard to meet as the state. You just have to be believable, or it has to be rational to think that maybe in some way allowing same-sex marriage or expanding marriage to include same-sex couples would affect the linkage between children and their bonds with their biological parents. So it occurred fairly typically.
Well, Dan, I want to ask you about the justices. Chief Justice Kennedy is believed to be the swing...
Justice Kennedy.
Justice, right? Justice. Kennedy is believed to be the swing vote in this case. Did any of the questions he asked indicate how he might vote?
It's very interesting, Peggy, because he expressed sympathy to both sides, in effect. On the one hand, he expressed sympathy to the idea that, as Glenn was saying, that you need to let the democratic processes go its way. There has been some shift in public opinion. Why make judges the heroes of this story? On the other hand, he said, I'm not buying some of the arguments that you're talking about in the interest of children and so forth being necessary to prohibit same-sex marriage. So he was hostile to those who are opposing same-sex marriage, but he was also very sympathetic to the idea that maybe this isn't something the Supreme Court ought to decide. Maybe it's better left to the people themselves.
So no idea on how this might go with him? Not
with him, and he really is the swing vote. There are things that he has written as far back as 1986 that suggest he's very sympathetic to the democratic processes. On the other hand, he has written 3 major gay rights rulings since 1996. So there you are.
And his questions tracked exactly the major points he made in his opinion 3 years ago in validating the federal ban on same-sex marriage. So that was provocative.
And speaking of that, a few years ago, the Supreme Court, heard the challenge to California voter-approved Prop 8. So that case didn't decide constitutional rights.
It didn't, because it turned on a technical question of the standing of the initiative proponents of Prop 8 to continue to appeal the process after the Attorney General and the Governor declined to defend Prop 8. So it was decided on grounds that did not go to the constitutionality of state bans. And so that's the issue the court has before it today.
And Dan, as you're saying, they can't avoid it this time around.
Well, they can't. And also in 2013, at the same time they decided the Proposition 8 case, they also decided a case by the name of Windsor, which invalidated the Federal Defense of Marriage Act. And in that case, the court, Justice Kennedy, writing for the majority, said, look, the law that prohibits the extension of federal benefits to same-sex couples could not stand. Justice Scalia, conservative justice who dissented, said, if you read that opinion very carefully, there are the seeds of striking down bans on same-sex marriage that are passed by the states. The only question is waiting for the other shoe to drop.
And Glenn, we'll have to end it on this. Could this ruling have an impact either way it goes here in California?
If the court allows states to decide for same-sex marriage, bans, if the court allows bans, then that would undermine the legal theory on which Prop 8 was rejected and declared unconstitutional. In theory, there could be a revisiting of that. I think politically the issue here in California has shifted and tolerance of a same-sex marriage ban is gone. But there could be some legal skirmishing and some political advocates who want to fight about it.
Well, we'll learn about this in June, I understand, by the end of June. All right, Glenn
Probably
Smith.
The last day.
Yes, Glenn Smith and Danny, and thank you very much.
Nice to see you, Peggy.